Okay, now we will consider section 76. The text of the section 76 of Indian Penal Code reads like this. Act done by a person bound or by mistake of fact believing himself bound by law. To make it simple, let us read it like this. Act done by a person bound by law, or the act done by a person believing himself bound by law. In the second category of case, he believes himself bound by law by mistake of fact. So for better understanding, let us rephrase this heading like this. Act done by a person bound by law, or act done by a person by mistake of fact believing himself bound by law. That's the heading of the section. Now let us look at the text of the section. The section begins with the words, nothing is an offence. That means whatever will be described in the section is not an offence. Nothing is an offence which is done by a person who is bound by law to do it. Simple. इसका मतलब ये हुआ कि जब भी कोई व्यक्ति ऐसी कोई कृति करता है जो करने के लिए वह कानूनी तौर पर बाध्य है, ऐसी कृति गुनाह नहीं कहलाएगी. Or nothing is an offence which is done by a person who believes himself bound by law to do it. Now here the belief plays important role. It is the belief of the person which makes all the difference. The person may not be actually bound by law to do that action, but if he believes it, then it is not an offence. But then one condition must be fulfilled. The belief should be formed on the basis of certain factors stated by the section itself. Now what are those three factors? Let us see. So the belief should be formed on the basis of because of the reason of mistake of fact. It must not be by reason of a mistake of law, and the belief must be formed in good faith. So that means that ऐसी व्यक्ति जो अपने आप को मिस्टेक ऑफ फैक्ट की वजह से, ना कि मिस्टेक ऑफ लॉ की वजह से कोई भी कृति करने को कानूनी तौर पर बाध्य समझती है, बिलीव करती है, तो वो ऑफेंस नहीं कहलाएगा, वह गुनाह नहीं कहलाएगा. That is what section 76 says. For your clear understanding, I will state the section once again. Section 76. Nothing is an offense which is done by a person who is bound by law to do it, or who, by reason of mistake of fact and not by reason of mistake of law in good faith, believes himself bound by law to do it. Now, Indian Penal Code itself gives two illustrations. The first is of a soldier and the second is of the officer of the court. Let us understand those two illustrations. These two illustrations will make the section very clear. Now suppose there is a soldier and he has been ordered by his superior officer to fire on a mob. Now this superior has ordered the soldier to fire on a mob in accordance with the commands of the law. That means because the law gives that superior officer the powers to give an order to his soldier to fire on a mob, that superior officer has given that order. And in accordance with the order of the superior officer, the soldier fires on a mob. So here the soldier has not committed any offense. Now let us take a look at another illustration. there is an officer of the court whose name is A. Now that officer of the court has been ordered by the court to arrest a man named Y. Now that officer of the court makes some inquiry and believes that Z is Y, and he arrests Z. The section says that in this case, that officer of the court A has not committed any offense. Now you can see, even if there was no arrest warrant for Y, still Y's arrest made by the police officer does not make him guilty of any of the offense under Indian Penal Code. Or that means the offense of wrongful confinement under section 342 of IPC. Why? Because it was only after making reasonable inquiries and on well-founded grounds the police officer was convinced that ZY was Y, and while arresting Y he believed that he arrested Z. This belief of the police officer was in good faith. In good faith he believed that he was bound by law to arrest Y, because there was a direction from the court of law by issuing a warrant to arrest him. So because of honest belief of the police officer, in good faith and by reason of mistake of fact, to believe that Z was Y, this police officer will be protected under this section, that means section 76 of IPC. To understand the section in a proper perspective, it will be better to understand the term mistake of fact. Mistake of fact is some error of opinion as to the real facts. A mistake of fact or ignorance of fact is generally a defense. We will also understand another term called mistake of law. What is a mistake of law? Mistake of law means a mistake about existence or non-existence of any law on a relevant subject. It also consists of a mistake as to what the law is. So in case of mistake of law, the mistake may be about existence or non-existence of law, or about what exactly is the law. Mistake of law, whether civil or criminal, cannot be a defense in law, howsoever genuine it might have been. All the residents of a country, whether the citizens or foreigners, are bound by law of the land. This rule is founded on the famous principle that every man knows the law, or at any rate ought to know the law under which he lives. Now, interestingly, it may not be possible even for professional lawyers to know the entire bulk of law, but still, this rule has been recognized as a basic principle of law on the ground of judicial expediency and public policy. Imagine what would happen if ignorance of law or mistake of law is made as a defense. In such cases, it would be open to an accused charged of a crime to say that he was not aware of the law on the point, and in such a situation, it would be very impossible for the prosecution to prove that accused was knowing the law in question. Resultantly, every accused in every case would be acquitted, and administration of justice will be impossible. So a mistake of fact is a defense, and a mistake of law is not a defense. Now let us see the difference between mistake of fact and mistake of law. To understand the difference, Let us take one illustration. Let's say there is a police officer named A. Now this police officer is empowered to arrest a person committing a cognizable offense, say like murder. Now suppose if this police officer arrests a man named B, mistakenly thinking that this B has committed a murder, but the fact of the matter is that the B had killed someone, that means a dacoit, in self-defense. In such a situation, the police officer A is not liable for committing the offense of wrongful confinement because his mistake was one of fact. Now suppose in the same example, if B has, instead of committing a murder or killing a dacoit, B had committed a simple offense of assault, but the police officer wrongfully thinks that it's a cognizable offense, when in fact it's not a cognizable offense, and the police officer arrests that person B. Then in this case, the police officer is liable for wrongful confinement because the mistake of the police officer was about law and it was not about mistake of fact. And for this kind of mistake of law, the police officer cannot be excused.